in these meetings. So now we're at the third round. The third round is 6 minutes to the Conservatives, 6 to the Liberals, 6 to the NDP, 6 to the Liberals. And then we have agreed that at the end of this round, the three other representatives of not recognized political parties in the House of Commons, because you need 12 seats, will be allowed to ask 3 minutes of questions each. So we will start with the Conservatives. Monsieur Berthold? Monsieur Berthold.
Mr. Berthold, thank you very much. Chair, and Mr. Butch, in your testimony, you've very clearly said that his departure from the Department of Justice, that this had nothing to do with SNC-Lavalin. Mr. Chair, I'd like to ask the witness, why did the Quebec government receive an indication on several occasions, even in Gatineau at the end of January, roughly 15 days after the cabinet shuffle, that the whole SNC-Lavalin affair was solved and that there would be a DPA? How can the Quebec government believe that such an agreement was already arranged if everything you wanted to do when you made repeated communications with the former Attorney General was to put pressure on her to obtain outside counsel? How could you suggest to another level of government that this agreement was already a done deal? How could the new Attorney General make the right decision? This doesn't fit with your testimony. Because after a cabinet shuffle, well, now we have a minister, and we suggest to another government that there would be a deal. This doesn't really fit with what you said from the beginning.
The situation you're describing, I'm not aware of any communications between the Government of Canada and the Government of Quebec on this issue. Certainly not in the time frame you're talking about. Well, that's not true. I'm aware of the fact that the Premier of Quebec, the current Premier of Quebec, raised it personally with the Prime Minister, as did the former Premier of Quebec, but I'm certainly not aware of what you're talking about.
Donc, vous n'êtes pas au courant
So you're not aware of any communication that could have happened between members of the cabinet or members of your office at that time with members of the Quebec government suggesting that SNC-Lavalin, thanks to the cabinet shuffle, would have a remediation agreement, and such an agreement would be a done deal?
Monsieur Butch. Je laisse maintenant la parole à Monsieur Coupe.
Great. Thank you, Mr. Chair, and thank you, Mr. Butts. You indicated that you know Mr. Bouchard and Mr. Marquez well. Would it be fair to say you spoke with them every day?
No. Well, for, I would say, 4 of the weeks in question here that you're examining, I was in Washington. So not every day, no. Certainly not in the affected time period.
But they were briefing you?
From time to time on a wide variety of matters, yes.
And so you would have been aware of their activities on the file in general terms?
In general, yes. I
Okay.
mean, I certainly gave them overall direction, and they would report back from time to time.
Okay. And you mentioned that you were briefed by Prime Minister immediately after the September 17th meeting?
Sorry, I didn't hear that.
At the meeting with Ms. Wilson-Raybould, the clerk, and the Prime Minister, I thought I heard you say you were briefed immediately after that meeting on the 17th.
I did not say immediately after, and to be honest,
Okay,
I don't recall whether the clerk or the Prime Minister debriefed me on the meeting.
The Prime Minister asked for an outside opinion at that meeting?
Not that I know of.
Not
no.
that you know of. But we do know that on October 18th, Mr. Bouchard asked for an outside opinion to Jody Wilson-Raybould's Chief of Staff. The answer was no. On October 26th, again, Mr. Bouchard asked for an outside opinion to Jody Wilson-Raybould's Chief of Staff. The answer was no. On November 22nd, Jody Wilson-Raybould was called by the PMO to meet with Mr. Marquez and Mr. Bouchard, where again the issue of an outside opinion was raised. Again, Ms. Wilson-Raybould said no. And then on December 18th, you, at the meeting with Ms. Prince, in conjunction with Ms. Telford, again, were asking for an outside opinion several months later. Mm-hmm. What possibly could you have understood her answer to be ever been no, and that therefore she had made her decision. She was not going to overturn the decision of Director of Public Prosecution.
So those are two different questions, whether she would accept external advice and whether she would overturn the decision of the DPP. And in fact, the distance between those two things, Mr. Cooper, I believe, is the heart of the matter at hand. My perspective on this, and it was informed by professional public service advice, was that there was nothing wrong with discussing this. And as I said in my testimony, I was not pressing in any way, shape, or form that anyone overturn the decision. And I think it's really, really important that we establish that as a fact. And it is...
No, but you were basically...
Please let me finish, sir, with respect.
Yes.
And it's an important fact because it is one of the few facts that seem to be shared. The minister testified that last week, and that was certainly my understanding. What I said in my statement about the meeting with Ms. Prince was that I sought to understand the minister's reticence on that file, on the concept of receiving independent advice, and made the case for doing so as a matter of sound public policy.
In other words, there was not a respect for her judgment to review the facts and review the law in the exercise of her prosecutorial discretion to overturn a decision that had already been made by the DPP, having regard for the facts and having regard for the law.
Could you just note that's the last question? I'll let the witness respond.
Sure, and I'm happy to respond, Mr. Chair. And I should have said this more vividly at the outset, but I appreciate the opportunity to come here and speak with colleagues. I think it's an important matter you're discussing, and I hope that the evidence that I've provided can aid in your deliberations. At the end of the day, we really didn't feel that anybody was doing anything wrong and that these were honest discussions. And I would ask you to deliberate on the question. If this was wrong, and wrong in the way it is alleged to have been wrong, why are we having this discussion now and not in the middle of September or October or November or December?
Much. We're now going to go to Mr. Assassi. Mr. Assassi, you have 6 minutes.
Thank you, Mr. Chair, and thank you, Mr. Butts, for appearing before a committee. It's been very helpful, especially your opening comments. Now, in your remarks, you delved into at length the decisions that animated the changes in cabinet. Mm-hmm. And my question for you
Which I'm sure will make me a lot of friends, but I was under obligations to do so.
Absolutely. Now, my preliminary question is, you were saying in your opening remarks that the first time SNC and the issue of deferred prosecutions came up was by Minister Philpott. Is that correct?
In the context of the cabinet shuffle, yes.
Yes. So prior to that, before you had reached out to any of the new people being appointed, there was no discussion whatsoever about deferred prosecutions or SNC?
Certainly not that I recall. I mean,
Thank you. Now, my second question is, when the Prime Minister spoke to Ms. Wilson-Raybould and advised her of changes to Cabinet, was there any suggestion at that point that she did not have confidence in the Prime Minister?
No.
Third preliminary question. Before Ms. Wilson-Raybould resigned from Cabinet...
You mean on that day in the debrief?
On the day that the Prime Minister actually
yes.
called her to inform
Correct.
her
Yeah.
of her new position, there was no suggestion that she had no confidence in the
No.
Prime Minister. Before Ms. Wilson-Raybould resigned from Cabinet, did she ever suggest to you that she did not have confidence in the Prime Minister?
No.
Thank you. Now, if we could go back to the issue of obtaining a legal opinion or perhaps retaining an expert. During the period that you served in the Prime Minister's office for 3 years, were there other instances in which new legislation or a new legal regime was being considered or contemplated in which the Prime Minister's office decided to obtain a legal opinion?
I'm sure there were. It's a pretty standard operating procedure in my view.
I would think so.
Yeah.
Now, you said the first you heard about the need to obtain outside legal counsel was that was one of the recommendations that was made by the Department of Justice.
I'm not sure I would. It's been a long time since I read that memo, Mr. Assassi, so I don't want to be categorical about this. I don't know if it was a recommendation or an option, or since we seem to be having a bit of a Jesuitical discussion about fine definitions, I don't want to say something that is incorrect.
So would you mind telling us one more time why you thought it was a good idea to obtain outside legal expertise?
Sure. I thought that in a case like this, where so many people's livelihoods were at stake, that, and this was a shared view, it was an obligation of the government to make sure that we availed ourselves of every, that we took a really hard look at it, because you wanted to be able, when you go knock on your doors on the weekend, you wanted to be able to look employees of the company, pensioners, the supply chain in the eye and say, we gave this a good hard look. And that was all that was motivating us.
Absolutely. Now,
The people involved.
Thank you for that. Now, in your opening remarks, you also said that the first time you heard that the Attorney General had made up her mind on this issue on September 16th or 17th,
Yeah.
the first you heard this was last week during the course of her testimony.
That is correct. That is correct.
Now, given that you were not aware of that, would it be fair to say that your expectation was that she would consult with other departments?
Yeah, I think I want to be really careful here, Mr. Assassi, because, and I think Ms. Wright alluded to this earlier, I don't have any sense of what's in the Section 13 order, and nor should I. That would be inappropriate for me. But we thought broad consultation was really appropriate. Yeah.
Okay. And I take it you are familiar with open and accountable government?
I am indeed, yes. Pages 66 and 67, I believe,
Yes,
cover this
that's
subject.
right. So you've had an opportunity to read
Of course,
the various
yeah.
passages that would be relevant to this
Yes.
particular case. Now, the first passage actually says that it is appropriate for the Attorney General to consult with cabinet colleagues before exercising his or her powers under the DPP Act in respect of any criminal proceedings in order to fully assess the public policy considerations. What does that tell you, that particular passage?
It tells me, frankly, that nothing inappropriate happened here.
Okay. There's another passage on the same page. It says interdepartmental consultation is also important because of the shared responsibilities among government departments. Is it your opinion that the DPP regime or the SNC-Lavalin file is one that would require interdepartmental consultation?
No question about it.
Thank you.
Mr. Rankin.
You just said to Mr. Assassi that the first time you'd heard about her decision being final was last week. I think I heard
That's correct.
that
I said
correctly.
that in my opening statement.
So in her testimony, she refers Ms. Wilson-Raybould to a November 22nd meeting with Mr. Elder Marquez and Mr. Bouchard, and she said in her testimony that she took them through the Director of Public Prosecutions Act, prosecutorial independence was a constitutional principle, etc., and they continued to plead their case that we could hire an eminent person. They were kicking the tires. I said no. My mind had been made up and they needed to stop. Enough. So I gather that Elder Marquez and Mr. Bouchard work for you?
They work for the Prime
For the
Minister.
Prime Minister's
ultimately.
office, of which you are the director?
And yes, myself.
Their
and Katie
report is to
Telford.
you, and so they knew, at least, it seems, if her account is to be believed. She said, I'll briefly pause about my state of mind. Final decision had been made, and so forth. In my view, the communications and efforts to change my mind on this matter should have stopped. Various officials also urged me to take partisan political considerations into account, which was clearly improper for me to do so. We either have a system based on the rule of law, the independence of the prosecutorial functions, and respect for those charged to use their discretion and powers in a particular way, or we do not. So she said very clearly to your staff that this was to be the final decision. Mr. Butts, what we're here to do, this is to determine whether a line was crossed, whether there was independent, whether the line we must preserve between an independent Attorney General's function and appropriate considerations of relevant public policy factors was crossed. It seems clear from her testimony that subjectively she felt inappropriate pressure. Whether that's true or false or right or wrong, there's no doubt that's how she subjectively felt. But objectively, given all of the interventions, all the times she said no, the fact that there was no new evidence to be brought forward, the hounding that she claimed existed, how can we but conclude that that line was crossed?
Well, I think that 20 points of contact over 4 months is not a lot of contact, Mr. Rankin. And I think that if she felt at the time that the line had been crossed, then she should have been, she had lots of opportunities at her disposal to make that clear and put it on the record.
So telling it to your senior officials wasn't enough. It had to be someone else she had to go to.
I'm not going to comment on what happened in a meeting I wasn't present for, Mr.
Right.
Rankin.
So
But I do believe, as I said in my statement, that if something this wrong had happened, that she had an obligation to at least inform the Prime Minister in writing. Yes, I believe that to be true.
Mr. Angus will use the rest of our time.
Thank you. I just want to follow up on what my colleague started, because on September 21st, she stated that this decision was no longer hers because the issue had been filed in court. It was no longer possible. You tell us you just became aware that her mind was made up last week. I find that surprising. November 22nd, the PM asked Mr. Bouchard to meet. She told him they needed to stop, and yet you're just now aware of this. December 5th, she says that she met with you at the Chateau Laurier and that Jerry took over the conversation and said, we need a solution. He said, I needed to find a solution. That's where she said that you didn't like the law because it was a Harper law. Then December 7th, she receives a letter from the PM and says that this is before the court. Then December 18th, there's an urgent meeting where they said, you said there was no solution that does not involve interference. And Katie Telford says, I don't want to debate legalities. And then December 19th, Mr. Wernick pressured her to speak to the prosecutor, and she said at that point she was waiting for the other shoe to drop, and the other shoe did drop. She was let go. And she asked you when she was being let go whether or not this had to do with SNC, and you had asked her if this was questioning the integrity of the Prime Minister. How is it possible that you could run an office with that many people pressuring the Attorney General, and now you're surprised and didn't know what was all going on around you? How can you be credible to us when Ms. Wilson-Raybould gave us such clear, consistent testimony of a pattern of interference in an independent prosecution?
That is not my testimony. My testimony is that, as I said at the outset, I have a very different version of events. And I will say, I am not going to cast aspersions on a former colleague. I think that I tried to explain.
But just in all fairness, I just want this on the record. But I have
Mr.
a right
Angus,
to ask because
Mr. Mangus, your preamble was a minute and a half. I'm just going to let the witness finish the answer. Mr. Angus.
Did she tell the truth? Yes or no? That is the question. Not whether you're trying to be mean to her. That is not the question. If she told us the truth, then your testimony and the testimony and the credibility of the Prime Minister's office is in question. That is the question today.
I believe that everything I have said to this committee today is the truth. and I believe I described the events as they happened.
Thank you very much. We'll move back to Mr. Assassi. Mr. Assassi, you have 6 minutes.
Thank you, Mr. Chair. Now, I'd be remiss if I didn't point out to a third passage on page 67 of Open and Accountable Government. The third passage reads, formal consultation may also be warranted in cases that are of significant public interest, which raises legal issues of national importance, or which involve certain specialized areas of law. Do you think in this particular instance, it would have required that the Attorney General consult perhaps with the Department of Finance?
That sounds like you're asking me to do a technical evaluation based on the meaning of the law, but I think a common sense approach to this is that you take all of the input from your colleagues, and if you think that that input is appropriate, you tell them it's inappropriate. And if it gets to the point where you think it's as inappropriate as the former minister clearly now thinks it was, then you should inform the public at the time.
Thank you for that. Now, we heard from Ms. Wilson-Raybould during her testimony that she first received a notice from DPP regarding SNC on September 4th while in Australia, that she returned to Canada 8 days later on September 12th, and that by September 16th, she had made up her mind. In your opinion, would that have provided her enough time to do her due diligence, to consult with various departments?
Well, I think I covered that in my testimony, Mr. Sassy. I think it's a challenging explanation for the people whose jobs were at stake.
Absolutely. And you were explaining it to us today that your understanding is that when the public prosecutor is considering a particular file, that any time new evidence comes to light, that there should be a consideration of the matter, that one has to look at it with fresh eyes?
That's correct. That's my understanding. It's also my understanding that it's not possible to come to a final decision until the court process plays out and a verdict is rendered.
So are you concerned that she made her final decision before she actually consulted with the Prime Minister?
I think I have a lot of concerns about this, but I'm not sure I would agree with that characterization. I just think that I think that it was incumbent upon the people who were trying to put advice and evidence in front of the Attorney General to do so, and I think it was incumbent upon her to hear it.
And now, perhaps I shouldn't ask you what your expectations would be of others. Perhaps I should turn to how you look at this particular issue. And I'd like to ask you, do you have any regrets as to how this issue was handled?
Well, I like to look forward in life, Mr. Sassy, but we're all human. We all make mistakes all the time, and part of improving your professional life and your personal relationships is to examine the mistakes. On this case, I've looked at it really closely over the last couple of weeks, and I firmly believe that nothing inappropriate occurred here, and nothing inappropriate was alleged to have occurred until after the cabinet shuffle. Yeah, I mean, more broadly, there are other issues, but there are probably places and times and forums for that.
And in your opening statement, you mentioned you corresponded with Ms. Wilson-Raybould regularly. You expressed deep concern by what the minister was saying during some of those...
You mean post-cabinet shuffle? Yeah.
Yes, correct. You've expressed concern about that. Can you share with us today what the minister said and how that led you to determine there was a breakdown in communications?
Yeah, I think that part of her characterization of those conversations, and there were at least 4 or 5 of them, and they were long and they were personal and they reflected two people trying to deal with a very difficult issue. There was a point where the minister asked me directly if her departure from the Ministry of Justice and Attorney General had anything whatsoever to do with the SNC-Lavalin matter, and I said no. And I did say, I asked her in a surprised tone whether she was questioning the integrity of the Prime Minister. It wasn't an accusation. It wasn't a threat. It was genuine surprise that someone that I had spent so much time with and that the Prime Minister had spent so much time with could interpret the request being the move in such a dark light, to be honest.
And lastly, you do indicate that the Prime Minister did offer her the portfolio of Indigenous services.
That's correct.
Why was that important to the Prime Minister, and what did he have in mind when he offered her that portfolio?
Well, not very similar, as it turns out, to the, as everyone in this committee knows, the Splitting Vine Act was a Royal Commission recommendation, and when the Prime Minister, through the cabinet shuffle in 2017, I believe in the summer, I could be wrong about that, created the new Indigenous Services portfolio, he made a really strong point, I felt at the time, of appointing Minister Philpott to that portfolio. She was obviously in her dream job in health, and she took on that role because we had a collective understanding, as you folks know, around the government about how important the reconciliation agenda is. And we wanted to make a very strong statement. The Prime Minister wanted to make a very strong statement that the agenda was not going to slow down, which is why he wanted to appoint Minister Wilson-Raybould to the role.
We now have Ms. May, Mr. Plamondon, and Mr. Weir each for 3 minutes, and then Mr. Rankin has advised he wants to make a motion, but perhaps we can do that after we excuse the witness. So, Mr. May, Ms. May.
Thanks. And I'm going to disclose that I'm friends with the witness, and I would be okay with the first name basis. So, it's okay with you, Chair.
It is.
I am surprised that in your evidence you don't make reference to two people that I think played a very big role in this drama, the clerk of the Privy Council and the lawyer for SNC-Lavalin. So I'm going to ask how it is that you don't seem to recognize that the heaviest intimidation of our former Attorney General came from one-on-one meetings with the clerk of Privy Council September 19th, and that with that following phone call December 19th, and I will let you know I completely believe every word we heard from Jody Wilson-Raybould without a doubt. So how is it that your evidence doesn't make reference to his actions, and did you know that he was going to phone her at home on December 19th and make veiled threats?
No, I'm aware that the clerk and the Deputy Minister of Justice are appearing later, so I know you'll have an opportunity to speak to them directly, but I will say about the clerk of the Privy Council, whom I've gotten to know fairly well over the past 3.5 years, that I find the accusations leveled against him completely inconsistent with his character. He has made enormous family and personal sacrifices to continue to serve the people of Canada. And I just can't imagine a circumstance where Michael Wernick would do the things he is alleged to have done. I find that even less credible given the fact that I am alleged to have done things I know I didn't do.
Well, I would only say, Jerry, that I still think that your evidence can be consistent with Jody Wilson-Raybould's, the extent that you were massively distracted by other events, out of town for 4 weeks, and could have forgotten things. But I don't find contradictions to the extent of he said, she said. But I'll move on to Frank Iacobucci, who is described in the one-on-one meeting that the former Attorney General had with the clerk as not a shrinking violet. Now, in the same period of time where there's a lot of pressure from SNC-Lavalin, Mr. Iacobucci, of course, is a distinguished former Supreme Court judge, was retained by the Prime Minister's office to handle the Indigenous consultations on the Kinder Morgan matter. Did that lead to you having conversations with SNC-Lavalin's lawyer on the subject of these threats that they might leave the country?
No, I've never had a conversation with Justice Iacobucci on SNC-Lavalin.
Can I ask then, did you seek independent evidence of any evidence that there was a threat to jobs? This is all riding on the threat to jobs, but based on the 2018 audited financial statements of SNC-Lavalin, they currently have $15 billion in back orders. They have a very secure financial situation with gross revenues of $10 billion. Is there any evidence that jobs were actually at stake by letting this go through the courts and letting the independent Director of Public Prosecutions do her job and the Attorney General also do her job?
Well, that's too bad. That's my understanding from Department of Finance briefings. But I have to say it's been a long time, and yeah, I can't recall anything specific. Liz?
Merci. On va passer maintenant à Monsieur.
Thank you. Now we're going to move to Mr. Plamondon. The floor is yours.
I cannot cite a specific study being done on a specific day by a specific person. I was briefed multiple times on that.
Thank you very much for that clarification. Monsieur Plamondon?
Mr. Plamondon, I appreciate the interpretation that we have here at the House. Well, if I understand correctly, on what precise date, since the decision had been made at the beginning of September, on September 16th, the minister decided at that time to not use the DPA. So at what time did you have the certitude at the Prime Minister's office that she would not change her mind, that she had made her decision? When were you informed that she had made her decision to not use the remediation agreement and to move to prosecution? At what date?
Thank you for your question. I think it's a central contention of my testimony that it was not possible for her to come to, for the Attorney General to come to a final decision before a verdict is rendered. So I was never aware until last week in her testimony that she believed that she had made a final decision on the 16th of September.
Okay. Et lorsqu'elle a...
And when she did raise the question on December 5th at your supper, was she the one who brought up the issue, or was it you? It was her who brought up the issue? Yes, correct. And even at that time, her final decision in her mind was already made since September.
I'm not sure how to explain that because as I said a few times, I don't believe it to be the case.
Et dans la loi qui a été votée,
And under the law that was voted a year ago that allows these famous DPAs, did the two ministers who quit vote in favor of this law?
Sure.
et au caucus, je veux dire au
And at the ministers' cabinet, did they discuss this legislation? Was it unanimous?
Mr. Chair, that's outside the scope of, because the matter went before Cabinet last spring. Yeah, I can't comment on that.
Et une dernière question sur ça.
One last question. On this bill, it allows the minister to intervene and to say, no, I'm going to reach an agreement rather than to prosecute the company. And up to when? Is it until the judge makes a decision, until that time, until a verdict is made, that she can intervene to ask for an agreement outside of court? Is that the case? Is it still possible at that time?
To be the case, my understanding from the briefings I got at the time was that intervention was still possible until a verdict is rendered. And I think it's important to note about the concept of remediation agreements where they came from in the first place. It was an attempt to, we hear a lot about competitiveness around here, and it was an attempt to harmonize economic policy in Canada with many competing jurisdictions that already had this instrument at their disposal. There was a rigorous debate, as there always was on this topic, and there on most topics, and there were people on both sides of the policy. But at the end of the day, it was the collective decision of cabinet that it was a policy that was worth pursuing in the economic best interest of the country. And if I could say one more thing about DPAs, I think that they've been badly mischaracterized as a get-out-of-jail-free card, when what they really are is a court-approved reform process for a company that had committed very serious acts, and their purpose, and it's really important, their purpose is to protect people who had nothing to do with those acts from being harmed by the law.
Une dernière
Unfortunately, you had 4 minutes and 30 seconds. I'm sorry. Thank you.
Merci beaucoup. We're going to go to Mr. Weir. And Mr. Weir, by the way, I did check, and it was true that your question at our last meeting was the first CCF question at a committee meeting in 60 years of the Canadian Parliament. So it was quite historic. Mr. Weir?
Well, thank you for the opportunity once again, and thank you, Mr. Butts, for your articulate and informative testimony. To pick up on what you were just saying about deferred prosecution agreements, we heard last week from Ms. Wilson-Raybould that it was clear under the law that SNC-Lavalin was not eligible for a deferred prosecution agreement, and that therefore efforts to push that option were inappropriate. I think it's clear that you and many other people believed that SNC-Lavalin potentially was eligible for a deferred prosecution agreement. And I appreciate you're not a lawyer, I'm not either, but I'm wondering if you can shed any further light on the company's eligibility for that type of remedy.
I could not shed any light on that legal matter, Mr. Weir, I'm afraid.
Okay, it seems quite central to whatever misunderstanding or disagreement occurred.
Well, the centrality of it, though, with respect, I'm sorry, I didn't mean to interrupt you there. The centrality of it is that the law is really unclear because it was brand new. And in this circumstance, my understanding, as I said in my opening statement, is that this is the first case in which the law could be applied. So I think talking about these things as if they are matters of settled law, again, with the proviso that I'm not a lawyer, is a bit of a mischaracterization of the state of the policy, which is really fresh and never been applied. And we thought the more thought and advice and process that could go into this, the more transparency we could bring into the decision-making process, the better off we were all going to be going forward. It was we were plowing a new field here, and wanted to make sure that all of the lessons were learned and all of the wisdom was gathered and all of the advice was given.
So thanks for all the light that you've shed on the cabinet shuffle in January. With the benefit of hindsight, do you think that it was a mistake to move Ms. Wilson-Raybould?
I don't like to do retrospective recharacterizations of events. I think that the government was put in a very difficult position, and I think in particular the Prime Minister was put in a very difficult decision. I think that there was no malice toward anybody, and there certainly wasn't personal malice toward anybody. The Prime Minister made, I think, a well-informed decision about the cabinet shuffle, and had everybody on the team done what the Prime Minister asked of them, then I think we would not be having this conversation today.
Thank you very much.
Thank you.
Mr. Rankin, would you be okay if we excuse the witness before we move to the motion?
That's fine.
Okay, so Mr. Butts, of course.
Sorry. before I leave that it was a real honor to be here. I appreciate very much the work that you do in all parties, and I hope that my evidence has contributed to a real public policy discussion. And I thank you all for your time and friendship. Thank you.
And in return, I want to thank you very much. I think your testimony was very helpful. Hearing your perspective was very helpful to our work. So thank you very much, Mr. Butts. And I'm just going to suspend for 1 minute so everybody can shake Mr. Butts' hand, and then we'll resume.